This is the Dan Gemus Real Estate Show. Heard every Saturday and Sunday from noon to 1 p.m. right here on AM800.
Thank you for doing a good job as always.
Now back to the show with broker owner and host, Dan Gemus.
Okay, welcome back to the show. I am Dan Gemus. Heather Marintet in studio with me today.
Hello.
And we're having lots of fun. Beautiful day. The sun is shining.
It is.
Can't beat that.
No, I love it.
What do you say we chat with our good friend Christian Janisse from Simplyclose. Hey, Christian, Happy New Year to you.
You as well. How are you both doing?
We're doing
Great.
fantastic. Thank you. It's a nice day out there, so we're enjoying that. And what's happening in your world? The first time on the show for this year, so thank you for joining us again in 2025. It's been a great year this past year with you and all your tips. So thank you for that.
Yeah.
So what's happening? What's the latest in Christian's world?
I think we wanted to talk about just generally. We've covered the same topics a few times, but I guess going into 2025.
Yeah.
You know, what do we most commonly see as being like an area of dispute and just entering into agreements of purchase and sale in general? Because when somebody's buying or selling a home, you know, they go through a realtor almost 99% of the time. And it
Yes.
can be fast paced, but surprisingly fast. Like you might think you have this large asset, it's going to be a long, tedious process, but once you make that decision, the realtors move incredibly fast. The market moves incredibly fast. Next thing you know, you're at showings, offers in. So in terms of tips, the biggest thing that I see, and it's funny, like last week we had like a Facebook chat group that was talking about like what are the most common issues that all the other lawyers in Ontario see, and it's the chattels. Mm-hmm. So there's this one paragraph, you know, the agreement of purchase and sale, it's 6 pages, but there's this one paragraph on the second page, and it talks about what chattels are included. The fixtures, so the difference between chattel and fixture, basically if you flip the house upside down, whatever falls is a chattel, whatever stays is a fixture. That's like the most simplistic way to think about it. The agreement says what fixtures are excluded. So for the most part, it's left blank, and you don't have to worry about that. The other part says what chattels are included. And this is where almost 9 times out of 10 when we run into an issue on closing, it has to do with, was the microwave included? Was the, dishwasher included? Shelving units, which are a gray area. In my opinion, when in doubt, spell it out. If you want a TV mount, if you want a shelving unit, you should still put it in there, even if it's a fixture. So just chattels in general, like make sure that you go through the house before you submit the offer, or at least you contemplate every single thing that you could possibly want and just spell it out as simple as possible, so that both parties are in agreement and say, yep, both were aware that was what was included.
One of the biggest points that we often have to clarify, or in this confusion, like you mentioned, is the TV mount.
Yes.
People, I'm like, it's tied to the wall. Yep. So if you turn the house upside down, it's not going anywhere. So
right.
That should be
the mount,
included with the
not
property.
The TV.
Exactly.
Yes.
Yes. Right.
Yeah.
So.
No, I agree, and that's where things get a little murky. But obviously, if you have like an experienced agent that's possibly ran into these issues or concerns before, they can help guide you through that. But even though that's a fixture, no doubt, I don't think that there's any doubt that that's a fixture. There are certain things like that you should still put in, even under the chattels, even though it's not necessarily a chattel, just to make it clear.
Avoid confusion. Yep.
Yeah, well, I mean, in fairness to buyers and sellers, they don't always really know what a chattel or a fixture is, so they might think like, oh yeah, like of course they're getting, like the most common chattels are like the appliances.
Sure.
So they might think, oh yeah, like of course they're getting all of that, but nobody contemplates, am I getting the TV mount? And then oftentimes with these chattels, while they can be expensive, they're usually not so expensive that it's worth pursuing a claim afterwards. Right. For example, a TV mount, if it costs $100, it costs $180 to file a claim in small claims court. So at that point, not only are you going to be waiting, but you're going to end up spending more out of pocket. So it can be very frustrating, particularly for first-time home buyers who are maybe having a difficult time getting into the market, and then now they found out, I've got to buy a new TV mount, and they didn't really plan for that. And then they're going to have these new mortgage payments. So always try and spell out exactly what you want in the agreement of purchase and sale, and actually read it. It's only 6 pages. The first page is basically like largely empty, fill in the blank. So there's not much reading to do on that page. But a lot of people just don't read it and then are shocked afterwards. And I think it's just because of how fast-paced the market moves. Like once you start putting in offers on a lot of places, it can be difficult to remember, like, oh, like did that house have a built-in microwave or not?
So aside from chattels, in this chat group from all the lawyers across the province, what else was a hot topic?
Well, probably not going to be the most interesting for everybody else, but the requisition date. So there's like this title search date, the date that the lawyer has to do the title search by. So when you buy the property, let's say you put in an offer on January 1st, it gets accepted. The closing date's not going to be until February 15th, for example.
Sure.
There's that time period between the day that the offer is signed and the day that you actually take possession, where the lawyer in the background is searching the title to the property to make sure that everything's clean. A lot of times, realtors will put 5 days before, and the issue with that, particularly if you're the seller, because if you're the buyer's lawyer, you have to do the search. So if you wait until the last minute, the seller has to fix it. But it can be frustrating because it says 5 days, and then the seller finds out there's a permit because I did my deck, but I've owned the house for 20 years, and I never thought to call the municipality and have them come back and do an inspection. It could be very simple to fix, but now they've got 5 days notice to do it.
Yeah.
And it may even be less than 5 days, because by the time the buyer's lawyer notifies the seller's lawyer waits a day, then it's a weekend, right? Like it's just real estate. Everything can kind of move slow, and you got to deal with the municipality. So that was the second biggest thing. And then honestly,
so what would you recommend as an ideal timeline for that date? Is it is 10 days or 7 days or longer? What's your preference?
We do it as early as we can, so within 30 days, but for 14 days would probably be ideal.
Okay.
But I've seen this week I saw one that said 3 days, and it's just if there's an issue, and for the buyer's lawyer, they're operating off that day, depending on how many deals that firm does. They might be that's the absolute deadline, and if they're living off deadlines, then it can be frustrating for buyers and sellers, because although it can be fixed, there's now 3 days notice, and now it's a scramble. This is always the challenge with real estate.
Of course.
But the third biggest thing that they said was that, because everybody, this is actually, you'll probably find more interesting than the title search date, because that's super boring, is the holdbacks. So a lot of times when you're dealing with an issue like, say, chattels and fixtures, like the seller took the TV mount, you're fighting. The clients will always say, well, we're fighting about it, so just hold back the money. We can't. So that was the third biggest thing that people said, is that people don't understand. It can be frustrating that when you put something in the agreement, or if you don't put something in the agreement, you can't just impose it on your own afterwards.
Right.
So if you put that the chattels and fixtures are in good working order, but if they're not, you can't just automatically hold back whatever $3,000 until
whatever you
resolved.
think.
Yeah.
Okay.
So holdback clause. But then the issue with the holdback clause is that it's you don't know what the issue is going to be. If the stove's not working, you put a holdback for $5,000. That's way too much money.
Sure, it
it
is.
probably costs you $200 to fix. So it's very difficult to foresee what could happen.
Okay.
That's true.
Fair enough.
The good news is most people are reasonable. For the most part, if something happens between the time that you put the offer in and the time that it closes, if for whatever reason the fridge broke, most people are pretty reasonable and will either get it fixed beforehand, or they'll give money to compensate the buyer for the fact that they're going to have to deal with it afterwards.
But Christian, you know as well as we do that these issues don't happen to the reasonable people. They always happen to the unreasonable ones.
It's true. Yeah. It depends. If you're buying off somebody who is of an older demographic, they're usually more reasonable and more understanding.
Yes.
If it's an investor, they're usually more profit-driven and saying, oh, well,
Yeah.
that's fine.
100%. So listen, great tips today. If anyone has questions, how do they reach out to your team?
They can call us at 519-997-3775 or email us at hello@simplyclose.ca.
Fantastic.
Thanks,
Christian Janisse, thank you. Appreciate it.
Have a good day.
Thanks. That's Christian Janisse, real estate lawyer with Simplyclose. Great tip today. Yep. So there you go. Hopefully you learned something. And what do you say we give away a gift card?
Ooh, let's do it.
Richmond Popcorn Company. If you want to win a gift card, you can be caller number
4.
Caller number 4 right now, 519-792-10 519-792-2559, 519-792-CKLW, and you'll take home the gift card for the Richmond Popcorn Company. And there you go. Take a break. We're going to answer some questions right after this, right here on the Dan Gemus Real Estate Show.